So the first thing that I'll discuss is affirmative covenants. So an affirmative covenant is basically just a promise that means that the parties have to agree and adhere to certain terms. The opposite of an affirmative covenant is a negative covenant, which is also referred to as a restrictive covenant, which basically means that one party has to cease or not do something. So from the case, the term for the affirmative covenant says that normal and customary covenants found in transactions of similar size and complexity, the affirmative covenants shall include a use of proceeds provision. So just on that, the use of proceeds provision just means that the proceeds from the venture capital funding that Return Logic is going to get means that they need to be used in good faith and used the way that they said they were going to use them, essentially. And so this means that they'll promise to use those funds wisely for the investors, and that if any other sort of similar issues come up, that they're gonna keep that promise. And I think that they should accept this provision, this term. It's pretty reasonable and pretty normal to see that in a lot of contracts. So the next term I'm going to discuss is legal fees and expenses. A legal fees and expenses term basically is just highlighting who has to pay the lawyers or the attorneys to, write the contract or settle disputes or anything else that might come up legally in the course of, creating this agreement. In the case, the legal fees and expenses term says that the company agrees to pay the reasonable legal fees and out-of-pocket expenses of the investors' counsel. So this means that Return Logic has to pay all of the legal fees and anything else that might come up. I think that they should accept this term. It's pretty reasonable and standard. If they were to renegotiate, they might maybe consider like an outside counsel. It sounds like they have to use the investors' counsel, which might be more expensive than hiring their own lawyer. But I still think that's pretty reasonable and that they should be able to accept that just fine. Next is the right of co-sale. So the right of co-sale basically just is a type of provision that means that investors have to have a say and be able to participate if the company decides to issue or sell any further securities. So in the case, it says that if the current equity owners propose to sell all or any portion of securities of the company owned, the investor will have the right to participate on a pro-rata basis in any such sale of securities of the company to a third party. So this essentially just means that the original owners and founders of Return Logic, if they want to sell any securities like common stock, they have to talk to the investors first, and the investors are going to be involved in that sale. It's something they have to do together. I think that they should also accept this term. It's pretty reasonable, and it makes sense that the investors would want that. If they have a 45% ownership in the company, they're probably going to want to have a say in how those shares get sold. The next provision is the right of first refusal. So the right of first refusal is essentially a contractual right that one party has, meaning that they have the right to enter into a certain business transaction first, and they have the right to do that before anyone else has the opportunity. And if they refuse that right, then, or if they refuse to go into that business transaction, that means somebody else can come in and do it. So the case says that the company will have the right of first refusal to purchase any securities of the company which the current equity owners intend to sell or otherwise transfer to a third party. Should the company not exercise its right of first refusal, the investor will have a right of refusal to purchase such securities. So this means that Return Logic has the right to purchase any shares in the company first. An example is that if one of the founders maybe wants to sell their shares, or they just want out of the company, the other founders have the right to purchase those shares and that ownership first before the investors do. And I think they should accept this term. It's favorable to them. They have the rights to purchase any shares first, so that makes sense to me. The last term is preemptive rights, and a preemptive right offers select shareholders of a corporation the right to buy any future issuance of common stock. And so from the case, it says for preemptive rights, until the first public offering of the company's common shares, the investor shall have a right of first refusal on all additional securities proposed to be sold by the company other than common shares to be sold pursuant to the incentive stock option plan or upon conversion of the preferred shares. So this means that if Return Logic decides to issue other shares, which they had discussed doing as part of a incentive stock option plan, that the investors have the right to purchase those shares or some of those shares first, and they get to see them first. This is something that I think they probably might want to renegotiate, just because that means that if the investors have the opportunity to purchase more shares in the future, they could have more ownership in the company. And from reading the case, it sounds like the investors already had about 10% more ownership than the founders were planning on. So that might be something that they would possibly want to renegotiate. And these are some of my sources. A lot of the information I got is from Law Insider and Investopedia.com.